earlier panel I presented this idea that we lump copyright infringement all into one singular thing, this tort copyright infringement, and this results in us being unable to individually tailor the liability rule in various different contexts. This is one of the problems, one of the extensions of that idea. Is a paper I'm co-authoring with Oren called Copyright Accidents. The idea being that because we think infringement all is one thing, we don't distinguish accidental infringement from any other type of infringement. Okay. So, what do I mean when I say accidental? Here is a picture of Chicago's L. I'm not sure. It actually might be the L right outside of DePaul, but one of those. I have copied this into my PowerPoint slides. That's fine. This is an academic conference. That's fair use. Imagine if I copied this photograph in a situation which was not so clearly fair use. For example, I'm writing a history of Chicago's transport system as a commercial book and I'm going to sell it. Okay, maybe you can make a fair use argument, but it's not clear. So, in that context, copyright expects me to find the author, find the copyright holder, and negotiate a license. But doing so is quite difficult. You look at the photograph, there's no copyright notice on it, there's no metadata. I don't know if it's under copyright, I don't know who is the copyright holder, if it still is. I don't know if the copyright holder would object. It's totally plausible that the copyright holder would just say, yeah, sure, go ahead and copy, I don't mind. So, notice the position I'm in at this point. I'm thinking about copying it, but it's very uncertain. At this point, I'm faced with a risk. It's not certain that what I'm going to do is a copyright infringement. I can only perceive a certain probability that my actions will be an infringement and will cause some sort of cognizable harm to someone else. Okay? So what could I do in this situation? Well, I could go, okay, fine, I just won't copy it, I'll do something else. That comes with an opportunity cost. Or I could say, well, I'll undertake a search and try to find the relevant copyright holder. But again, that comes at a cost. Or, alternatively, I could say, well, I'll just take the risk. I'll just copy it, and if someone turns up later, the copyright holder, I'll pay whatever remedy or rewards. Okay. So this is what we're talking about when we say copyright accidents. That point where you're faced with this risk of harm to someone else. If you go ahead and copy, and it does ultimately result in infringement, it's an accident. It's not intentional. You haven't intended harm. It's an accident. Just as in the same way that accidents are found all over tort law. So imagine you're in one of the cars there, instead of, and you're driving along Jackson. This is an activity which is generally socially desirable, socially beneficial, but obviously comes with risks of harm to other people. So you're driving along, there's a risk of harm to others. You can take certain precautionary measures to prevent that risk materializing into a real harm for someone else. You could drive slower, you could check the mirrors more often, be a better driver. But it all comes at a cost. You see? So we're in the same position here. The copyright accident is exactly the same as accident in tort law. A position where you're thinking about doing something, and you're doing something socially beneficial, copying, but at the same time it poses risks to other people. So, the question is, how do we deal with these accidental infringements, or these problem copyright accidents? Well, question is, who should bear the burden of the unintended harm? You take the action, you copy, and it causes some harm to someone else. Should that harm stay with the person who's harmed, the injured party, essentially what we say a rule of no liability? Or should the harm be shifted back to the copyist in all cases, strict liability? Or, like most cases of accidental harm, should this be governed by a negligence rule? So, that is the question underlying this paper. In these cases of copyright accidents, then what should we do? Should we have a strict liability or a negligence rule? And just a footnote here. Copyright accidents are everywhere when you start looking for them. Orphan works. The problem behind orphan works is copyright accidents. That there's a risk. You're University of Michigan and you want to digitize all works. You don't know whether that's going to infringe someone's right or not. It's just a risk, probability, and you have to take into account the probabilistic nature of the actions. Okay. So, should copyright accidents be governed by strict liability or negligence? We argue that they should be governed by a negligence rule. To demonstrate, we'll think briefly about the economic analysis of accidents developed in tort law. We should briefly think about some other competing normative theories, and then if we've convinced you that a negligence rule is appropriate, then we'll go on to think about what we need to do here. Okay. So the economic analysis of tort law says that tort law is about giving actors an incentive to behave efficiently. In the context of accidents, that means trying to minimize the social cost of accidents. That means getting actors to behave in a way which minimizes the total cost of the accident, but also the total precautionary cost. So we're trying to minimize these two variables. Which rule will accomplish this? Well, a strict liability rule has some merits. So imagine that, to go back to my example, I'm making a commercial history of Chicago's L, or Chicago's transport system, and I'm faced with the rule of strict liability. Because of the strict liability, I internalize any harm done to the author, but I also internalize the cost of preventing that harm, the measures I could take to prevent an infringement, like the search costs or the opportunity cost of just foregoing the use altogether. Because I internalize all of the costs, I can be relied upon to take the least costly action, the least costly opportunity. Okay, so far so good. Strict liability gives me, the user, incentive to behave efficiently. But there is a problem when we think about the other part in this situation. So, not only myself, the user, can take actions to prevent the infringement, but also the owner can take actions to prevent these accidents occurring. They can take steps like attaching notice, registering the work, recording a transfer, investing in new licensing models, acting expeditiously against third parties who might have some bearing on the analysis. The point is, both parties here can take some actions to prevent the accidental infringement and the accident occurring. Now, we see that the strict liability rule gives me the incentives to behave well, but what about the owner? Well, the owner has no incentives to prevent these accidents occurring under a strict liability rule. You're going to get compensated every single time that an infringement does occur. So for them, they're indifferent between just collecting damages or trying to prevent the accident accident actually occurring. But note, these measures are often very cost efficient. These are often cost justified. The cost of the measures will often be lower than the benefit they provide in reducing the possibility of accidents. So this is where a negligence rule becomes appropriate. Under the negligence rule, myself, the user, I still have the incentive to invest efficiently in precautionary measures, but because I shift the burden of the harm back onto the author or back onto the copyright owner by acting reasonably, by taking reasonable precautions under the hand formula, that means the copyright owner internalizes the harm flowing from accidents where the other party, the user, has taken reasonable precaution. So because the other party, the copyright owner, internalizes this harm, he has an incentive to reduce the risk of it occurring. In more copyright terms, just think about an owner, they're thinking about putting notice on their work. Why do that under a strict liability rule? Why go to the effort of actually trying to put on a notice or anything else under a strict liability rule? Because every time someone copies your work, you'll get damages, in theory. Now, if you know that you're only going to get damages when the user behaves inefficiently, unreasonably, fails to take reasonable precautions against the infringement, then you have a decent incentive to actually put the notice on the work and take any other precautionary measures to prevent the accidents occurring. Okay, so that is the main reason why we should expect to see these accidents governed by the negligence rule, just as we see accidents in all other areas of tort law governed by negligence. Now, you might ask, okay, incentives for behaving efficiently is certainly an important part of this, but are there not other elements we should consider? Yes, and we can talk about them in the Q&A. The simple answer is it doesn't actually change the analysis very much. In fact, it strengthens the analysis. We can come back to this later if you want. I will also come back to this second point later as we're running a little low on time. The simple point is a negligence rule distributes risk far more equitably than what we see at the moment. Currently, users bear all of the burden of these accidents. At least under a negligence rule, the burden would be borne sometimes by the user, but sometimes also by the copyright owner. Far more equitable. Okay, so if we've convinced you that copyright accidents exist and that a negligence rule would be appropriate because that gives both parties incentives to reduce the risk of the accident to an efficient level, then what do we do about that? Well, we surveyed a number of options. We thought about trying to add negligence into the elements of infringement. We thought about a system of proxy rules. Ultimately, modifying the fair use doctrine to take into account accidents, accidental infringement, and particularly the concept of risk was the ideal way to go. What we propose is, I hope not particularly radical. What we suggest is that under non-accident cases, the case where someone knows with certainty that their work they're going to infringe, nothing needs to change. Equally, when there is an accident situation, but under the normal fair use analysis, that use would be non-infringing, then nothing needs to change there either. The only time you need to change the analysis is when there is an accident case, someone who is ex ante faced with the risk of infringing, and that would not be clearly fair use under the normal analysis. In those cases, you need to go an extra step and apply hand formula. That is, you need to ask, did the defendant take reasonable, hand-defined reasonable precautions against the infringement? If they took all reasonable precautions, then this use would be fair. If they failed to take those precautions, it would be unfair. Now, a simple example of this is the problem of orphan works, a systematic problem, and a good example of this problem is the Hati Trust case. So, here's a great example of a copyright accident. University of Michigan don't know whether they are going to infringe anyone's copyright. It might be fair use. There's a good argument that those uses are fair, but it's not airtight. There's certainly ways to attack the fair use analysis there. So in our setup, we'd say, okay, so the University of Michigan would only be liable if they fail to take reasonable precautions to prevent infringement. As some of you will know, they took very reasonable precautions in the sense that they searched for copyright owners, they published a list of potential works to be published, to be scanned and digitized online. They took all the reasonable precautions available to them. They should not be liable. Hopefully that'll give authors an incentive to actually proactively try to prevent the risk of accidental infringement. Okay, so in that case, I will leave it there. Final point is just to note that this, by thinking of copyright accidents, we hopefully put into this a coherent framework, a whole set of policy issues that so far have seemed disparate. Things like mass digitization, orphan works, when you have what we call a copyright triangle, when you have a third party involved in infringement. All of these cases involve copyright accidents, but just to link back to the presentation I gave earlier today, we don't make any sort of distinctions here because it's all the tort of copyright infringement. Okay, so now I'm going to turn it over to Oren to answer the Q&A.
Thanks, Patrick. So the deal with Patrick was that he would put me in as much trouble as possible, and I'll try to work my way out of it. I'm not sure that we helped is end of the bargain. I'll take questions.
So it doesn't really seem like an accident to me. I really appreciate what you're trying to accomplish. It just doesn't seem like a useful analogy. It's not every source of uncertainty is an accident. There may be some legal uncertainty. There may be some uncertainty also as to whether anyone's going to notice what you're doing and come forward and sue you. But that doesn't really, neither of those seems like it's accidental. It's simply unknown ex ante. And the rest of the analysis seems fine, but I feel like you're piggybacking on the case that's been made elsewhere about accidents in ways that are not compelling at all. And so I feel like that weakens the force of the argument.
Let me just say what we mean
Yeah.
by an accident,
Yeah.
right? And then maybe we can take it from there. By an accident, we simply mean a case in which ex ante, from the reasonable perspective of the infringer, there's only risk of infringement as opposed to something close to certain.
Well,
Period.
that's just huge. Then much legal
Indeed.
trouble is accidents throughout the universe. If every time you don't know whether anyone's going to notice and sue you, the harm is an accident, then you get no strict liability ever, right? You can say, when I make a defective product, I don't know whether this is actually going to hurt someone. Maybe it'll just be this latent flaw in the product, and everything will be fine.
Right.
So I should be judged by a negligence standard rather than by strict liability.
So the answer to both of your points is yes and no.
Yeah.
A, yes, it covers a huge terrain. B is the answer that always we deal with it through the law of accidents, i.e. usually negligence. No. What is usually the dividing line, sort of soundbite standard analysis that I'm throwing into in 2 minutes. The dividing line is usually to what extent can we count on market transactions to deal with that, as opposed to liability that we have to impose on the party. So I'm using, again, sound bites. People usually use that as the distinction between trespass, which is often accidental in this sense, or at least sometimes accidental in this sense, and accidents dealt under negligence law in total. Why do we deal with this one that way and the other one this way? All of them might be accidents in some sense. The basic answer, which is usually given, is again, to what extent can we count on the market for parties to deal with that? To what extent it's going to be cost efficient in many ways once you're faced with such a risk to resolve the risk through the market. Go find out, go find the owner, go allocate the risk. Now, again, I'm doing it very quickly. We try to argue, and actually we rely on others who have already argued. We sort of take the argument from there. As it turns out, in copyright, often you cannot rely on the market to deal with it ahead. Then you're in the realm of real law accidents when you have to start figuring out, okay, so what's the rule? Okay, but I want to take other questions. There's a lot more to discuss.
So maybe the terminology that would be more intuitive to a lot of us is reasonable copyright infringement, right? Where the court said it was infringing, but it was a close case of fair use. It was reasonable of you to, take the chance. I don't object to you calling it copyright accidents. I think rhetorically, like what you're trying to do by framing it as an accident is say, hey, the law has tools for this that would be good to use here, and that makes sense to me. But I think there is a substantive point underneath it too, because I think it actually is sort of radical, the solution that you're pushing. If you frame it as, if you reasonably thought it was fair use, what it sounded like was you said, well, if you reasonably thought it was fair use, then it is.
No.
Right?
No.
That's okay.
The answer is no.
Give the clarification.
No, I want you to actually ask the rest of the question, but actually for our purposes, we distinctly and officially don't deal with legal accidents. You didn't know the law, it was this way, now it turns out actually that it's that. We put aside legal accidents. That's a very complicated issue we don't want to touch. It's not about you didn't know the law, you assumed something about the law even if it was reasonable. It's not about not knowing the law.
Even if the law is gray.
Not about the law, not that.
Got it, okay.
We don't deal with it. Everything you said is right. There's a lot to discuss there, but it's not about the uncertainties of the law as the law. It's about many other uncertainties. Not even one more.